Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Thanks for watching. Let's get straight to the docket. First, Lori Vallow's son leaves a tribute to JJ and Tylee. You're going to want to see this. Second, we're going to answer a question that shows up quite a bit in the comment section. What do you mean they're not charged with homicide? The bodies were found on their property. Third, what is the root cause of wrongful convictions? Fourth, an update on the Los Angeles County sheriffs who were ambushed and an update on the manhunt. Fifth, we're going to give you an update on the professional poker player's death. That's right, there was a preliminary hearing. Some new information in the South Dakota Attorney General's case when he struck the man on the side of the road. And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk. Thanks for watching. Now, we've got a busy docket for you today, but before we get started, please, if you haven't done so already, hit that subscribe button, hit the like button, hit that little bell so that you receive notifications of when we go live or put up new content, which is daily, and always leave us a comment below about what we talk about today. First on the docket, Lori Vallow's son leaves a tribute to both JJ and Tylee. Let's take a look. JJ Vallow and Tylee Ryan's brother, Colby Ryan, recently visited the New Salem Memorial created for his siblings. The fence memorial is located across the street from Chad Daybell's Salem property where the children's bodies were found back in June. Now, most of our followers know that Chad Daybell married the children's mother, Lori Vallow, in November of last year, and it is believed that JJ and Tylee were murdered and later buried on Chad's property sometime in September. Colby left two separate messages on a poster board to his deceased siblings telling them how much he missed them and loved them. Tylee was 16 years old when she disappeared, and Colby penned the following. "I know that you are dancing in heaven," he wrote. Colby also told Tylee that he could see her in his own child's face. "You're the best sister and auntie. Your heart lives on in us. Tell Jesus hi for us," he wrote. To JJ, Colby wrote the following. "Your light and spirit shine on every day. We get to laugh with all the memories that we had together." JJ was just 7 when he disappeared, and ultimately when he was found deceased on Chad Daybell's property. There were several other signs out on the memorial, many asking for justice for Tylee and JJ. And this fence memorial apparently sprung up on Ray and Boyd Price's Salem property back in August after two women with a banner reading "Justice for Tylee and JJ" asked the Price for permission to create this memorial. It was created after the original memorial on a fence bordering Chad's property was taken down. The new memorial was created to provide a place for residents to continue to mourn. Many residents have placed several items on the fence as long as they don't quickly deteriorate. So that's a very nice tribute by Colby Ryan. And obviously, we've heard reports that he is not happy with his mother's non-cooperation with the police related to the disappearance and ultimate demise of JJ and Tylee. Let's talk some more news in the Lori Vallow case. Her attorney, as you may recall, filed a motion quickly stating that he had no objection to the motion for joinder. Simple enough. Well, now he is filing a motion for extension of time to file pretrial motions. As you may recall, we've discussed this. Under the rules, they have 28 days from the time that they enter a plea of not guilty at the arraignment. Mr. Means apparently needs more time, and he cites the following reasons for the additional time. First, he says the parties have agreed to the request for the extension, which means the prosecutor doesn't object. The other reason is he says that he hasn't yet received complete discovery as of yet, and therefore he needs additional time to get that. And finally, he needs to be able to review, analyze, and complete the discovery file in a timely manner to be able to file and address the pretrial motions. So this obviously puts the court in a predicament. The court sets certain deadlines, and you have to have very good reasons not to meet those particular deadlines. The question becomes, how much discovery has not been turned over as of yet, and why is Mr. Means not getting more assistance when it comes to going through this discovery? Based upon the amount of information we heard at the preliminary hearing, the discovery is going to be voluminous, and it's going to take a long time to actually go through it. There's going to be a lot of need for expert assistance. Hopefully, he's done that with his exorbitant retainer that he's received, that he'll be able to have those resources available to him. Somehow, I don't think that's going to be the case. But most judges are going to tell the defendants and their attorneys, I'll give you a little bit of time, a reasonable time to prepare, but the judge is going to really wonder how much of the discovery remains to be turned over, why hasn't it been turned over to date, and what has Mr. Means been doing to get up to speed on this case given the amount of time that has already passed. I'm sure the court does not want to extend trial dates if they don't have to, particularly because of discovery that hasn't been turned over. One other motion that Lori Vallow's attorney has filed is that he is asking for a change of venue because he does not believe that he can find an impartial jury in the Fremont County there in the great state of Idaho. Mr. Means cites some perfunctory rules under the Idaho Criminal Rule 21, as well as the 6th and 14th Amendment of the United States Constitution and the applicable sections of the Idaho State Constitution, which basically means you have a right to effective assistance of counsel and a right to a fair trial. However, Mr. Means does not provide any substantive argument for his motion. In fact, only asks that the court order a briefing schedule and a motions hearing so that they can, in fact, explore this issue. I can tell you, if you're going to move for a change of venue, you not only must file it, you better be able to have some information to show, more than just anecdotal information, that you're not going to be able to receive a fair trial. Mr. Means probably should have taken a little better swipe at providing more detailed information as it relates to this case. As always, the Lori Vallow Chad Daybell case has something new just about every day, and when it happens, we'll bring it to you. Now, next on the docket, we have seen this question many, many times in the comment section, as well as our live conversations that we've had with individuals, whether it's in our Patreon group or when we just go live on Tuesday nights. And that question is why are Chad and Lori not charged with murder? For God's sakes, they found the bodies of JJ and Tylee on the property. How much more do they need? Well, ladies and gentlemen, I'm here to explain it to you. In every criminal case, you have to have, and this is real simple criminal law 101 from your first year law school. You have to have an act with a guilty mind. So you have to have what they call actus rea, and I assure you, nobody uses that term except when you're in law school. And then you have mens rea, which is your mindset that the prosecution has to prove. Now, let's take a look real quickly here at count 1 in Chad Daybell's case. It's destruction, alteration, or concealment of evidence. And it's alleged very quickly that the defendant, Chad Guy Daybell, on or about the 22nd day of September 2019 and the 9th day of June 2020 in the county of Fremont, state of Idaho, did willfully conceal and or did aid and abet another to willfully conceal human remains, knowing that some human remains were about to be produced, used, and or discovered as evidence in a felony proceeding, inquiry, and or investigation by law, with the intent to prevent it from being so produced, used, and or discovered. So there's a couple of key words here, all right, in these charging documents. First, the word willfully, all right? Willfully. What does willfully mean? So willfully is the mental state. There are several mental states that an individual can be charged with in any criminal complaint. The first is intentionally, and that's when a defendant desires that his acts cause certain consequences or knows that his acts are substantially certain to produce those consequences. Then you have knowingly. A person acts knowingly when he knows the nature and or result of his conduct. A lack of knowledge can often excuse criminal liability under the defense of mistake of fact. Traditionally, intent has been defined to include knowledge. That's key, ladies and gentlemen. And a person acts purposefully when there exists a conscious objective to engage in such conduct or to cause such a result. And willfully is defined as encompassing the concept of intentionally and purposefully, as opposed to accidentally or negligently. And that's been used to imply like an evil purpose in crimes involving moral turpitude. The bottom line, what this means is that you have to prove not only that the remains were concealed there, you have to prove that Chad Daybell and Lori Vallow willfully concealed or aided and abet another to willfully conceal, knowing that those said remains were about to be produced, used, and or discovered as evidence in a felony proceeding. But it comes down to knowledge. So a lot of people ask, Scott, they found these remains on the property. Why is it they're not charged with murder? Well, they have to prove first who, in fact, harmed these children. It's not a gut instinct. It's not a suspicion. It has to involve evidence, usually an eyewitness or an admission. And that admission has to be corroborated by the physical evidence. We don't have people just confess, but there's no evidence to support that particular admission. That's why prosecutors are always looking for items to corroborate pieces of evidence or parts of the story from a defendant to corroborate, say that's true. It's not a false confession in any way. So you have to be able to show knowledge. Think about it. Let me give you a quick example. Who here has children? Raise hands, right? Do you ever let them borrow your car? Think about it. You say, hey, behave yourself, borrow the car, but be safe. Don't let anyone do anything stupid in it, right? So you drive the car after your child has driven the car. You don't know who was in the car with your children, but you take your kids at their word that there's nothing that you should be worried about. You get in the car, you get pulled over for speeding, and for some reason, the officer thinks that maybe you're being a little suspicious and asks, hey, would you mind if my dog back here, my drug dog, would, maybe search around your car a little bit? And if you, of course, not knowing or exercising your rights, say, absolutely not. I have a Fourth Amendment right. No, thank you. But the cop says, doesn't matter. Don't need that anyway. So he just walks the car around. The drug dog then says, there's drugs in the car. You say, sure, open it up. I have no idea what you're talking about. They find drugs in the back seat, stuffed in the back seat. Are you guilty just because the drugs are there in your car? You would probably say, no, you didn't know about it. Well, that's what the prosecutor would have to prove if they wanted that case to go to trial. There was, potentially the act of possession of drugs in our example, but there's no way that they can prove the mens rea, that one knowingly or even willfully tried to possess those drugs. Therefore, hopefully that case would not be filed in any way, because just because the drugs are in the car, they still have to prove that you knowingly possessed it. Similar to the crime that Chad and Lori Daybell are charged with. They have to prove that they knew the bodies were there, which is why I've said Chad Daybell is going to take the Sergeant Schultz approach of I know nothing. And for those of you who aren't old enough to understand the Sergeant Schultz quote, I guess you'll have to look it up, or maybe Frank can find a clip of Sergeant Schultz. We'll see what he can do.
Oh, I see nothing. I was not here. I did not even get up this morning.
So hopefully that answers the question of Why can't they be charged with murder? The remains were found in their property, for God's sake. You have to prove you knew they were there, and you have to prove the act plus the mental state. Otherwise, no crime. Now, next on the docket, what is the root cause for all of these wrongful convictions that we've heard about? Well, a new report has been put out, and you all can take it for what it is, but it was the Government Misconduct and Convicting the Innocent report, and it was published by the National Registry of Exonerations, which has been tracking all known exonerations in the United States for the last 30 years. Not really sure if they have any bias. Hopefully they're just producing the evidence, but they would be the ones to report this information since they're the one that's actually collecting the data. If someone is aware of other information, I would be interested in seeing it, but I haven't been able to find it. So every year they release this report, and it documents trends in exonerations of how often DNA evidence plays a role in determining an innocent person is behind bars, problems with eyewitness testimony, and of course, misconduct. This report drills into all of the exonerations they've archived up until February of 2019, which is roughly 2,400 cases. And these are people who have actually been convicted of crimes, sentenced, and then later cleared based upon new evidence showing that they were in fact actually innocent. According to the report, 54% of the cases involved misconduct by officials, which contributed to these false conviction rates. The more severe the crime, the more likely misconduct played a role when an innocent person was convicted, according to the conclusions of the report. According to the report, police and prosecutors in general engaged in misconduct at about an equal rate. 35% for cops, 30% for prosecutors at the state level. In drug cases, cops were 4 times more likely to have engaged in misconduct than prosecutors. And when it comes to federal cases, prosecutors engaged in misconduct at a rate of more than twice as often as police. In white-collar cases, federal prosecutors engaged in misconduct 7 times more than police did. The most common type of misconduct involved concealing exculpatory evidence. We've talked about exculpatory evidence. That is evidence, any evidence that would reduce or diminish the culpability of one accused of a crime. The prosecutor has to turn that over. They cannot hold it back and say, well, that's going to hurt my case. I won't turn that over. But it happens in so many cases. That's why you always hear about these exoneration cases coming about after usually the original prosecutor dies or leaves the office, because there's something in there that they've been hiding and somebody randomly turns it over, not knowing what it is, or somebody finds it and says, hey, we have to turn this over. It doesn't look like anybody's done that. And according to this report, they found that evidence was deliberately concealed in 44% of the cases that ultimately resulted in exonerations. The report, which totals 218 pages, outlines how prosecutors and police break the rules to get convictions, from fabricating evidence and manipulative conduct during interrogations to fraudulent forensics and flat out lying in court. Now, the question then becomes, who is ever held accountable if there is, in fact, an exoneration where misconduct was taking place and it was determined to be misconduct by the prosecutor or the police officers? Well, most of the time is no. So in all of those cases that have been analyzed, in only 17% of those cases was there any actual sanction against the prosecutor or police. And prosecutors are hardly ever punished for misconduct, even though the report notes that they are equally as culpable as police. Only 4% of cases did they find prosecutors disciplined in any way for misconduct. We've seen that a lot, where prosecutors withhold exculpatory evidence and no big deal. It's disturbing, and it needs to be punished in this criminal defense attorney's humble opinion. When you're withholding evidence that is affecting somebody's liberty and you send somebody to prison for that, seems like a fair exchange for me. You falsely convict somebody going to prison based upon your willful acts. Seems like you should go to prison yourself. Now, police officers, on the other hand, were disciplined in some fashion in 19% of all exoneration cases. And that's still pretty low, but police are far more likely than prosecutors to be criminally charged with misconduct in these cases. At least 30 officers have been convicted in cases where they were responsible for false convictions. We've talked about this before on Crime Talk, ladies and gentlemen. Yes, I am a defense attorney. I have done that for 25 years. But the reality of it is we need a fair system. And the only way that's fair is if the defense is giving everything that is potentially exculpatory. That's just the way the system is done. You don't get to hold it back or manipulate the system because you think they're guilty, but maybe you just can't prove it. Those aren't the rules that we play by. Now, and suddenly everybody's outraged by police misconduct. Well, I've been saying that for 25 years, and all my friends are looking at me like, is this something new? No, this kind of stuff has gone on for a while. And if you go back and you look at my previous videos, I've said prosecutors, judges who let bad cops that know that their question is of less than truthfulness coming out on the stand, that they allow it anyway because they're going to give the cop the benefit of the doubt. And besides, the defendant's probably guilty of something. Maybe it's just not this, right? That's not the way the system works. And if those people want to do that, they should not be judges and prosecutors. I don't know, maybe go be a police officer. I don't know, but they don't belong there. So it goes back to we need good judges telling the bad judges, you rule on the law. We need good prosecutors telling bad prosecutors, don't hide evidence. And we need good police officers telling bad police officers, you play by the rules. You don't need to rig the game against the defendant. If you're a great cop and you're building a case, you don't need to do anything unethical. Bottom line. All right, let's take a quick recess. Ladies and gentlemen, please go to crimetalksearch.com. Please sign up for a background subscription service. In today's day and age, it is very important for you to know with whom you are dealing with on a daily basis. With whom are you going out on a date with? This is the information you should know. And where can you get it done quickly and easily? That's right. Go to crimetalksearch.com, sign up for a background subscription service where you can cancel at any time, and you can search as many names of individuals in the United States anonymously. No one's ever going to know you did it. And when you hit that little return button, a report is going to be generated, and it is going to include as much information as that computer can search all those millions and millions of public records and find emails associated with the individual that you searched, phone numbers, social media information, criminal background checks, property records, marital records, bankruptcy records, civil judgments, all the things that you want to know about when dealing with somebody that you're going to get involved with. We've had people say, Scott, I signed up, I did a background check, and I found out the person that I was getting involved with had crimes against children in his background. Had another person say, I signed up, I had a person that I was going to do business with, found out they had a history of fraud in their background. It is worth the fee, ladies and gentlemen. You never know when you can do it, and when you sign up, you can do it at any time. Go to crimetalksearch.com. You'll be absolutely satisfied and happy that you did. Next on the docket, a quick update regarding the 2 LA sheriff deputies that were shot in an ambush. First, the reward has grown to nearly $300,000. Now, that is substantial money, ladies and gentlemen. What I've always said is that the threat of imminent incarceration tends to break the bonds of loyalty. But even more important than that is it's always about the money. Somebody is going to turn this criminal in for $300,000. And the shooter, although we'll give them the presumption of innocence, it's on video. And I'm telling you, that was nothing but an attempted cold-blooded murder. Bottom line. And whomever represents this individual, if they are found alive, they have a very difficult defense ahead of them. This was nothing but an ambush. There's nothing that anybody could say that this shooter was acting in self-defense, and it is no way justified whatsoever under the law in any way that I could possibly imagine. On a positive note, one of the deputies has been released. The other one obviously remains in the hospital. Now, what is the disgusting part is that there were people that were actually happy that these police were shot, and they went to the hospital and were chanting, "We hope they die." Ladies and gentlemen, that is disgusting. I do not care what your political beliefs are, whether you love the police, hate the police, they are human beings. And to pray for someone's demise such as that when they are absolutely innocent victims sitting in a patrol car, having no interaction with that alleged shooter in any way, that's disgusting. Could you imagine the outrage if police were outside a hospital of someone accused of shooting a police officer saying, "I hope they die," and chanting and blocking ambulances from arriving? It wouldn't be tolerated. And if you have even an ounce of intellectual honesty, you will say that's just wrong. It's wrong all the time. Next on the docket, an update regarding the case of the professional female poker player, Susie Zhao. Well, there was a preliminary hearing held for the man accused of her murder. And the medical examiner, Dr. Andrew Hanisch, testified that the poker player had her hair burned off, her tongue was charred, and soot was found in her airway, which the medical examiner states suggests that she was alive when the alleged killer, Jeffrey Morris, set her ablaze. Morris has been charged with first-degree premeditated murder in connection with Zhao's death. State records indicated that Morris is a Tier 3 sex offender with a 1989 conviction for third-degree criminal sexual conduct, force, or coercion. Evidence also came out during the testimony of the medical examiner that Zhao had injuries to her genitals, corroborating prior reports that she was in fact sexually assaulted with a large object. And for those of you who do not recall, back on July 13th, two men passing near the Potomac Lake State Recreation Area found Zhao's charred body. One of the men said they initially mistook the body for a Halloween mannequin. The investigators believe that Zhao was killed at the park sometime after 11:45 p.m. on July 12th. There is information to believe that Morris and Zhao somehow stayed in the same room in the Sherwood Motel in Waterford, but maybe not exactly at the same time. Cell phone records suggest the pair were at the motel during the same evening. Now, Morris allegedly told police that at some point he and Zhao left the motel to purchase alcohol. He then reportedly said that Zhao left the motel around midnight and took all her belongings, including her cell phone. Cell phone records, however, suggest, and they placed the phone at the motel until 5 a.m. on July 13th, obviously the morning after she was determined to be deceased. Records also indicate that Morris left around the same time and drove to a secluded spot in the Potomac Lake Recreation Area. And the police also allege, based upon his cell phone data, that he was in the area for roughly 7 minutes, which would be about enough time to do as he is alleged to have done. Now, Zhao was known on the professional circuit as Susie Q, and she lived in Los Angeles, but then moved back with her parents sometime in early June of 2020. Needless to say, the court found that there was probable cause and that there was enough evidence for the case to proceed to arraignment, and the matter was bound over to the district court. Next on the docket, do you recall the case of the South Dakota Attorney General who was heading home the other night, thought he hit a deer, and it turned out to be a man on the side of the road, and that man was discovered the following morning? Well, there's new information that's coming out. Family members of the man that was killed and hit by the car allegedly driven by South Dakota Attorney General Jason Ravensborg said he went to the scene of the crash and saw evidence that suggests Ravensborg's car was partially on the road shoulder before he applied the brakes. It has been reported that Ravensborg was driving back home to his residence in Pierre, South Dakota, after a fundraiser on Saturday night when he told police that he thought he had in fact hit a deer. Turned out he actually hit a man. Ravnsborg said in a statement that he and his chief of staff discovered the body of a man identified as 55-year-old Joe Bover at the site of the crash the next morning when the attorney general got out of the car to look for the deer that he thought he'd hit. Let me just tell you, this sounds a little weird, but we'll get to that. Now, police have released very few details about the ongoing investigation and have not confirmed how the attorney general first reported the accident, though Ravnsborg said in his statement that he called 911. The statement also reveals that the Hyde County sheriff that reported to the scene on Saturday night let Ravnsborg borrow his personal car to drive back to Pierre, South Dakota, rather than have him wait for a tow truck. Now, isn't that special? In the statement, Ravnsborg insisted that both he and the sheriff had no idea that the crash victim was a person until Ravnsborg returned the following morning with his chief of staff and happened to find the body. Ravnsborg also said that he didn't consume any alcohol at the fundraiser. Now, I don't know if Mr. Ravnsborg drinks, but my experience with going to political events of any kind, the one thing that is not in short supply is alcohol. Usually it's being provided by all the lobbyists trying to get the politicians liquored up. So I think things are a little odd here. First, it's unclear when the call was made. When did the police arrive? Why would Ravnsborg go back the following day with his chief of staff to look for the deer? And the fact that the police officer let the good attorney general borrow his personal car. Now, maybe that's just good old-fashioned policing, kind of Mayberry style, or maybe, it's just a little professional courtesy among law enforcement. As noted earlier, a family member of the deceased said he went to the scene to get a better handle of what happened regarding their loved one's death. And he put this on a post, and the family member states, quote, "At the time the brakes were applied, clearly visible due to tire skid marks, the right-hand tires of the car were well on the shoulder of the road. The stretch of US 14 has wide paved shoulders with rumble strips at the white line. I stepped off the tire skid marks and they went on for over 200 feet before there were two parallel blood skid marks on the paved shoulder. The first blood marks were 6 inches wide and 6 to 8 inches long. There was then a skip of about 20 feet before a wider blood skid mark closer to the edge of the shoulder that was about 1 inch and 20 inches long. There was then a skip for about 20 feet before a wider blood skid mark closer to the edge of the shoulder that was about 1 foot wide and 20 feet long. There was then another skid mark about 20 feet until a dried pool of blood in the grass on the edge of the road. The pool of blood was 2 feet from the edge of the pavement. I measured with a tape measure, according to the family member. The grass here had been mowed late this summer and had regrown to 8 inches tall. He measured it once again with a tape measure. This was the very edge of the grass, and the ground was nearly level with the shoulder of the road at the point. The ditch slope had not really begun yet. Black flies were buzzing in the area just above the pooled blood. The family member also states that he saw a flatbed truck carrying what he believed to be Ravnsborg's Ford Taurus, and noted there was a large hole in the car's windshield on the passenger side. The police apparently would not allow the family member to take photographs of the vehicle. Now, obviously, this family member may not be an accident reconstructionist. However, they provided some information. Those skid marks would certainly tell a story. I'm not going to hypothesize as to what it means because we do not know exactly where the individual was struck. An accident reconstructionist could be able to do this. And maybe, just maybe, it's my cynical nature, but it sounds like maybe somebody was getting a little preferential treatment for sure. Now, obviously, everyone is given the presumption of innocence, and the road on that particular area where this accident took place appears to be probably pitch dark in the evenings, and it may have been too late to actually break in any time. So let me know down below in the comment section whether this was something nefarious or whether this was just a bad accident. Next on the docket, our dumb criminal contestant of the day. Let's introduce our contestant, 28-year-old Emily Owens Sint. She was pulled over by the Enid, Oklahoma Police Department for not wearing a seatbelt. Miss Sint told the officer that it was her birthday, that she had lost her license and she needed to go to the bathroom. The officer ultimately found out that Miss Sint's license was revoked and she had a warrant for her arrest in another county. Now, while waiting for the information, Miss Sint revved her engine, cursed the officer at the scene, and sped away with her tires squealing. Investigators say she led the police on a chase for several blocks with speeds reaching 70 miles per hour. Once she was stopped, she was obviously taken into custody because they usually always get the people that are eluding the police. When she was stopped, they of course found a meth pipe with burnt residue inside of her vehicle, and she was arrested on eluding, reckless driving, driving under suspension, no seatbelt, no insurance, and possession of drug paraphernalia. Enid Police Department put out a Facebook post stating, quote, "Everybody poops, we know, but that's no reason to commit a felony and put in danger the lives of officers, other motorists, and pedestrians in the area. Also, be sure to buckle up. Seatbelt saves lives. Thank you, the Enid Police Department." Now, ladies and gentlemen, Miss Sint is our dumb criminal contestant of the day. And we've had dumb criminal contestants of the day where the police were actually going to drive the individual down to the restroom at the next business, but they decided to urinate on the police car or next to the police car. Now, Miss Sint should have simply said, "Ooh, I really gotta go." Because let's face it, police officers are human and they've all been there. Let's face it, we've all been there where you get that feeling. That warmth kind of comes over you and you think something's not right and I need to get to the restroom right away. But Miss Sint in this particular case should not have eluded the police, and there's no evidence that she actually ended the high-speed chase by running to the restroom and relieving herself. So Miss Sint, if you are in fact going to use that as an excuse, you may as well at least try running to the restroom or maybe pooping your pants. It'll be a little more sympathetic. Now, I know that's a weird one to leave it on, ladies and gentlemen, but you simply cannot make this stuff up. Please leave me a comment below. What do you think about Lori Vallow's son and his tribute to JJ and Tylee? What about the report regarding why these wrongful convictions take place? Do you think it's the police? Maybe it's just bad lawyering by the defense. Let me know. And are you a little surprised that the reward is only $300,000 for the individual who shot at and attempted to kill 2 LA County police officers? Let me know. And let me know if you think there's anything weird in the case regarding the South Dakota Attorney General. Thanks for watching today. Have a great day. We appreciate you taking the time to watch us on Crime Talk. We'll see you tomorrow.